Everybody, it's Rick. It is the 27th day of March. It's the year of 2019. If you need to reach me because you're interested in finding out how you can receive my paperwork, which requires a gift, my email is rick, R-I-C-K, 0327 at me.com. Okay, just please email me just for that, okay? No long emails. I don't answer questions, okay? I receive too many emails, all right? That's about it, okay? I mean, as I said in my last video, I can't help everybody, okay? The best way I can help people is by making videos. And if you're in the position where you can send me a gift, which is, I don't have, again, the gift is not a lot of money compared to a couple of people out there, okay, uh, that are asking for, like, they're asking for a good amount of money. And I'm not talking about my friend Armin Osiris. He provides you with very good stuff, okay? All right, so the people I'm referring to are the ones that have a hard on for me because jealousy. That's why, jealousy. Because my paperwork has been proven to help. Okay, I've helped people get their driver's license back. I've helped people get the child support removed from their credit. I've helped people get arrears removed, significant arrears removed. Okay, a couple months ago, 2 or 3 months ago, I made a video where a guy had like $30,000 in arrears, something like that. It was in the 20s, 30s, I forget, but it was removed because he submitted the papers and before he went to court, and the prosecutor, who I want to call the child support agency, they eliminated the arrears because they couldn't prove it. Okay, now if he didn't submit the papers, they'd be going on, it'd be showing on his credit report that he owes $25,000, $30,000 in arrears. All right, they use like guerrilla math, I call it. I mean, it's like some crazy math. What these maniacs will do is they'll go back to the date that the child was born. Let's just say you had no idea you were a father or a mother. This has happened, and you say you become aware that you have a child at the age of, let's say the child is 15, and they'll go back to the day of the birth and make it retroactive to the day. That's they can't do that, okay? Because one, they have to prove willful non-payment. So how is it willful non-payment if you are not aware of a child? That's not willful. But this is just goes to show how vicious they are. It's all about money. Okay, I just got an email from a guy yesterday from Maryland, Purnell, good guy. So he sent interrogatories to the mother, and she thinks she's under the idea given by the attorney, and I mentioned this in a video a couple of months ago, where the child support agency leads you to believe that the attorney is representing you, but the attorney is really representing the child support agency. Okay, it's a nice little scam. So we demanded to see proof of the debt So the attorney for the child support agency says, we're demanding retroactive arrears, and that is the debt. That's proof of the debt, okay? Because they had no proof of the debt. So using sarcasm, the attorney's like, well, we want retroactive child support payments, and that is proof of the debt. Meanwhile, she's answering the income withholding, the interrogatories. The interrogatories was sent to the mother, not the child support agency. Okay? This is the little tricks they play. I mean, there's a lot of, if you've been chosen, if you're unlucky to have received notice that the child support is after you, you're facing a serious uphill battle. All right, because you're dealing with serious organized crime, fraud, I should call it. I mean, just think about what I just told you. I forgot how they worded it. It was like I have it's the essentials for attorneys for child support. It's they have 12 chapters, and it was worded like, well, if they ask you if you're like, in other words, you have to tell. It was like you have to. I'm paraphrasing. You have to tell them the truth. So you got to tell them that you're not representing them. You're representing the child support agency. But in other words, they're implying the attorney should lead the custodial mother or father to believe that they're representing you, but they're really representing the agency. I mean, that's fraud. It's misrepresentation. All right. Just to, I like to show that my paperwork. Here's something that's very important when you get my paperwork. My paperwork gets accepted in court. And when they get accepted in court, you can build off of that. Okay? You can build off of that. This is no quick fix, guys. This is an uphill battle. It took me 4 years. Okay? This is not easy stuff. But you got to fight. So when you submit court paperwork and they respond, you can build off of that. If they don't respond, you can build off of that. You could file a default. Okay? So I went to circuit court to file everything. Clerk disappeared for roughly 30 minutes. That's very common with my paperwork, sadly. See, the clerks are a gatekeeper. They will use trickery not to accept your paperwork. And people who have my paperwork, I provide you 4 clerk's affidavits just for this, that you bring with you. You put your name on it, and then you bring it there, and you give it to the clerk. If they give you a hard time, say, excuse me, can you please put your name here and explain to me why you're not accepting my paperwork? Because really what they're doing is they're obstructing. All right? Because you're trying to enter evidence, and they're obstructing. The clerk is not allowed to do that. The clerk's ministerial duty is to accept the paperwork and file it. The only thing they're supposed to do is to make sure you have everything there. They're not supposed to read it. And if you ask them for any help, any instructions, they tell you, we're not allowed to give you legal advice. Well, when I'm not asking you for legal advice, I'm asking you for instructions. But in other words, they are instructed by the judges or the administrators of the court to not accept papers. Or what happened here, this happens all the time. They take the paperwork, they disappear 15, 20 minutes, a half an hour, and you know who they bring it to? They bring it to the judge. And then the judge is looking over all the paperwork. No, you can't accept this. No, you can't accept that. Bring it back. And then the big games begin. Then you got to say, no, you have to accept my paperwork. So long as it's signed, right? And so long as a copy is provided to the other party, that's all that's necessary. Okay? And I provide you all the paper on pleading paper. So they have to accept it. It's on pleading paperwork. That's what lawyers use. So they have to accept it. I get people like, Rick, how do I get the numbers off of the side? The numbers are there for a reason, guys. That's why it's there. All right. That's like, you say on page 1, line 10, such and such is stated. That's the reason why the numbers are there. But I literally get people, Rick, how do I get rid of the numbers on the side of the paper? Like, come on, guys. That's why it's there. It's there for a reason. All right. Anyway, I go on these tangents. I apologize because I don't talk to you guys all the time. When she returned to the counter, she was accompanied by another clerk. The other clerk said, "We're going to take all your paperwork. An excellent job." They're kissing his ass. "There is one $20 fee for a change of venue," which they shouldn't be charging for that, but he didn't argue. Sometimes, here's another thing, guys. Sometimes you just got to pick your battles, okay? Um, Received a couple of thumbs up. Good jobs from the clerks. Now it's time to hurry up and wait. The looks on their faces were priceless, not to mention, oddly, they were extremely helpful because they read the paperwork, they now know that they're dealing with somebody that's not a victim, that knows the law. My paperwork is well written. Okay. Here's another one. This, small win. He had the child support removed from his credit using my credit paperwork, which is in the validation of debt folder. So for those of you that have my paperwork, it's in the validation of debt. All right. We're looking at here administrative wage withholding. But here's the thing. I'm going to go over these real fast, but what I want you to focus on is that you have the right. If you're one of these people out there who were fired from a job, you're downsized, injured on duty on some type of workers' compensation, you are involuntarily removed from duty or from a job. Okay, it wasn't voluntary. You didn't quit. Okay, they don't tell you this because they'll tell you. Like, a lot of people are like, Your Honor, I was fired, and they don't. If you don't know what's up, they'll run all over you. Okay, but it's under what is it? 32.9 CFR, 45 CFR .32. All right. Yeah, it's 45 CFR .32, wage withholding. All right, I'll get to that. But also, you can also demand a hearing at any time. All right, so if you were, terminated from duty from a job, and it wasn't it wasn't voluntary, and you have proof or have proof of an injury, you can send it to the child support agency and demand a hearing, and you're going to present them evidence that, let's say you were terminated 6 months ago. Let's say you've been injured for 6 months, and they're adding arrears because you're not able to make the payments. You could fight that. Okay. So what we're looking at here is administrative wage withholding. All right. It's 45 CFR 32.1. Okay. Of course, I moved it. I apologize. Okay. The purpose. This part prescribes the standards and procedures for the department to collect money from debtors' disposable pay by means of administrative wage garnishment. See, administrative, not judicial. Okay. Your wages are your property. It's protected. They can only take your property by a warrant or a court order, some type of money judgment from a trial by jury. But this is these are administrative wage withholding, which was started under the 1996. It's an executive order 13019. The Debt Collection Improvement Act from good old Bill Clinton. He did a lot of things that were bad for us. Okay, and what the executive order does, it orders like agency heads to get together and create these administrative rules or whatever to collect your money. Okay, and that's what this is. All right. Authority. These standards and procedures are authorized under the wage garnishment provisions of here we go, the Debt Collection Improvement Act of 1996, codified at 31 U.S.C. 3720D, and the Department of Treasury Administrative Wage Garnishment Regulations at 31 CFR 285.11. All right. This part applies to all department operating divisions and regional offices that administers a program that gives rise to delinquent non-tax debt. Now what happens is they'll take the money from your tax returns. It's called a federal offset because it's a non-tax debt, okay, owed to the United States. Now, again, how can you owe a debt to the United States if you didn't enter an agreement with the United States? Did you enter into some type of loan agreement? No. What they're claiming is because well, here's the thing, that one of the requirements is so he's supposed to be receiving welfare. How many of you out there that the mother is not receiving welfare? Because they want to grab as many people into this child support collection racket as possible. Divorce people, they do it all the time. They want to get as many people involved so they can, every payday, collect as much money by income withholding as possible. They've turned this into a huge racket, every state. Every state receives, billions of dollars from this racket. All right. So I'm going to let you guys can read this. All right. Because I just want to get to the, all right. These are definitions. Again, you guys can freeze this and read it. All right. I got to get to that. This thing is slowing down on me. I apologize. This stuff happens to me all the time when I'm doing these videos. Okay. Garnishment means the process of withholding amounts from an employee's disposable pay and paying those amounts to a creditor. You know what a creditor is? Somebody that fronts you money. You remember entering into any agreement for that? Of course not. It's a racket. Okay. Okay. When you receive notice that you owe a debt or they're going to start income withholding, you have 30 days to challenge it. Okay. And you're going to send under 45 CFR 32.4 notice. Also, it's under 31 USC 3720 or 3716, the nature and the amount of debt. Those of you that have my paperwork, you guys have this in my child support package. Okay. And many of you have used it, and they always respond with some nonsense. They'll send a copy of the court order. They don't respond. This debtor's right is to inspect and copy department records related to the debt, to enter into a written repayment agreement with the department on the terms agreeable to the department. How many of you have done that? Nobody. Most of you are not. Okay. We did that. Now here's the under 32.5 hearing. You have a right to a hearing. Upon timely written request of the debtor, the secretary shall provide a hearing. Do you see any time? There's no time restraints. You could ask for a hearing at any time. Okay, they don't want you to notice, but you can. All right, you guys can read that. For the section C, oral hearing. For the purposes of this section, a debtor shall be provided a reasonable opportunity for an oral hearing. When the hearing official determines that the issues in dispute cannot be resolved by review of the document evidence, such as when the validity of the claim turns on the issues of credibility or veracity, blah, 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 blah. If the hearing official determines an oral hearing is appropriate, the hearing official will establish the date. Well, that's all bullshit. You could do it by phone. So let's say it's in a different state, you guys can do it by phone. All right, there's several slides for hearing. Okay, you guys can read it. Again, 45 CFR Part 32. Okay, content of the decision. Decision shall include a summary of facts presented, the hearing official's findings, analysis, and conclusions. Okay. And by the way, after you've had a hearing, you can get a judicial review. Then you could take it to a court and have a judicial review. Usually called a mandamus. Withholding order. This is what I love. Unless secretary receives, the Secretary of Health and Human Services is supposed to be the only person that can issue these income withholding orders. Okay, but obviously we know, or a representative, but we know that they're not. These child support agencies are just issuing them, unsigned. That's why in the back there's a box for issuing official, and it's blank most of the time. Okay, because that means they're not following the procedures. Okay. Amounts withheld. It's the amount set forth in 15 U.S.C. section 1673, subsection A2. Excuse me. Okay, you can go and look that up yourself. It's supposed to be 55%, I believe. All right. Again, all right. So now we're going to get to financial hardship. A debtor whose wages are subject to withholding may, at any time, request a review by the department of the amount garnished based on materially changed circumstances such as a disability, check this out, divorce, a catastrophic illness, which result in financial hardship. Okay? A debtor requesting such a review under paragraph A of this section shall submit the basis for claiming that the current amount of garnishment results in a financial hardship, along with supporting documentation. Look at this. The secretary shall consider any information. See, the secretary is supposed to be involved. It's hilarious. The secretary doesn't look at this stuff. Are you kidding me? If a financial hardship is found, the secretary shall downwardly adjust by an amount and for a period of time established by the secretary. Hilarious. Refunds. Ending garnishment. In accordance with Part 30. Okay, 45 CFR 30.30 is termination of collection activity. Okay, and if you have my paperwork, you'll have that. The employer of a debtor subject to wage withholding pursuant to this part shall pay to the department as directed in a withholding order issued under this part. I love this. The secretary may bring suit against an employer for any amount that the employer, this is how they scare the employers. Here's the big word, may. Okay? They have no grounds to issue punitive damages because it's an administrative order. Okay? All right, and that's it. It's under 45 CFR. All right. Let me see if I can find it real fast. And again, you guys can look this up yourself. All right, it's 45 CFR Part 32. All right, so I'll show you. Here's 45 CFR Part 32. Okay. See, administrative wage garnishment. It's right there. Okay, let me show you 30.30. Termination of collection activity. Okay. Now I want to show you guys something. Remember I was doing the videos a few months ago where, you could click on the word and look up the definition of what the word is, like with state. Remember state, all right, District of Columbia, blah, blah, blah. Watch this. Secretary. I click on it. I'm not allowed to look up. Like, here's the debtor. Click on it. Nothing happens. I'm not allowed to look up these things anymore. Secretary may terminate collection activity when the department is unable to collect any substantial amount through its efforts. The department is unable to locate the debtor. So there you guys go. Here's another thing, guys. Under the law, you're supposed to be personally served with notice. A mailman is not personally served. So when they mail you these things, you are not personally served. Okay, it's the mail. The mail is not considered appropriate service or process. Take it and mail it back. If they want to personally serve you, they're going to have to send a sheriff or whatever to you. Okay, you guys can look this up. We're already at 27 minutes. It's gone on long enough. All right, so you guys can look at the slides at your leisure. All right, you can turn down the sound so you don't got to listen to me. Okay, because I know some of you get tired of hearing my stories. All right, if I don't have the silver bullet, half you guys don't even want to listen to me anymore. All right, that's why I don't do the videos in my car anymore. Okay, because I found out that nobody cares. They don't care what I got to say. Unless I have slides with some type of visual aid, then I get people watching the video. So that's why I always do a video with slides. It's called a visual aid. You guys have something to study. All right, so there you guys go, right? What you guys can do to stop wage withholding, terminate it, get a hearing for a financial hardship. All right, so listen, I'll talk to you guys later. Bye.